Hello YouTube, this is Attorney Conwin reaching out to you today to talk about an interesting topic. It deals with hearsay evidence. So we always hear this term hearsay in general public, and I think most people understand what it means. It's just kind of like innately, I heard someone say this, and this is what I'm using today to prove to you what I believe. It's much more complex in the whole legal realm. So there's federal rules that govern hearsay, because hearsay can be very dangerous. Like, oh, you don't want somebody in court to just testify, oh, I heard her say this, and that's how we prove our case. No. So the legal system has dealt with this over hundreds of years, and they understand what it really means and how to control it. And hearsay is only permitted in a limited capacity. A lot of my clients come to me and they give me a lot of this hearsay evidence, and I explain to them that it's not going to hold up in court because they regulate and limit the scope of which hearsay can be used, as well as what can even be touched upon in regards to it. There are ways around it. A good attorney can get some of it in to kind of persuade the judge or the jury to rule in their favor, but I'll talk about the general concept of hearsay in the legal realm. First off, it deals with a statement that's made by an individual who is not trying to use that statement to prove a case or a claim against another individual. So it sounds very complex and convoluted. And it is complex and convoluted. So let's say I am saying my ex-wife told me that she is a drug addict. She didn't say it herself, right? And I'm trying to use her statement to prove that she's a drug addict or maybe not fit to take care of my children. So in that context, it's hearsay. But there's one way around it. It's actually not termed hearsay per se, because it can be said to be an admission that she admitted, and the court system allows you to use hearsay in a very limited capacity only when people admit to something, but it's still subject to what the judge believes is appropriate. So oftentimes another way to get hearsay in evidence is, I'm not trying to claim what she's saying is true, I'm just trying to claim that what she said was said. So let's say I will say, she told me that she is allergic to alcohol. But the case doesn't deal with her drinking alcohol or proving anything like that. The case deals with, let's say, she's a drunk driver. So I'm not entering this evidence, testifying in court that she's allergic or not allergic to alcohol. It deals with the statement that we're trying to assert to prove that particular statement is true. So I know that's complex. It really comes down to what she said. Am I using what she said to prove that it's true? What she said. Versus I'm using what she said to prove that she said that. So those two things are very nuanced, but can go a long ways in the court system to maybe prove your case. Dealing with drunk driving, and she's saying she's allergic to alcohol. She didn't prove it to me, but that's what she told me. I'm not saying it's true or false, but that's what was said. Versus she's saying she's allergic to alcohol, therefore she's allergic to alcohol. That is the big difference in hearsay and what would be considered just evidence that cannot be suppressed in a legal process. So an attorney, it's like playing chess. So an attorney can try to get this evidence in to try to paint a picture to the judge. Oftentimes they don't want certain stuff to just go up there and say, she said this, that's why she's guilty. There are many case laws on this, as well as statutes and rules to kind of govern what hearsay is. Admission is not considered hearsay, even though it would normally be hearsay. You can use hearsay to prove what I just gave you an example of what is considered hearsay to the court and what's just considered just a statement that was made. And then things that are actually even hearsay itself can still be admitted into court when they fall into certain exceptions. The reason why I posted this video today is mainly for people to understand that when they are suing someone, they have to have certain type of evidence and have to understand that the evidence has to hold weight in the courtroom. And hearsay itself on its face is not a way to prove your case. However, there might be some exceptions. Attorneys can kind of circumvent and try to get it in. Oftentimes you can't use it as evidence, but you can still state it so the judge hears it, the jury hears it, and therefore you can kind of paint this particular picture. However, officially is not evidence. Hello YouTube, I hope you enjoyed this content that we provide today, and if so, please slam the like button below, and don't forget to subscribe to our channel so you get notification of future content. Also, don't forget to leave a comment or a suggestion below in regards to this video or any other videos that you think you'd like us to do. We will be back with future videos. Thank you very much.